For the last 2-3 days, we have been talking about data processing agreements. The criticality, the necessity, the safety that the fiduciary or the controller gets, the safety that the processor gets, and the fact that they are the correct method of telling your processor what is he expected to do with the personal data. Is there a legal requirement? Let's talk about that in this video. Welcome to my YouTube channel where you daily see new content on data privacy. And as I said, let's talk about a legal requirement, if any, for a DPA or a data processing agreement. Why do we need to have a legal requirement? This is a very interesting point, Ideally, as a business, when I am sharing personal data or any kind of data getting processed outside my organization, I need to define all the parameters. But do all the businesses actually do it properly? You don't know, right? So when it comes to personal data, the regulators say, no, you have to do it. And apart from just explaining, you need to be very clear about what is the role and responsibility of you as a fiduciary, them as a processor. You need to be very clear about what is expected. And as I said earlier also, it's ideally should be that you created a privacy notice, you set up a expectation of your data subject to get information from him. In Indian context, is a principle to get his personal data, right? You promise something, document that as it is as a DPA with your third party because you are getting it processed as it is. Whether it's about retention, whether it's about the way it is going to be processed, right? And then, of course, based on that documentation, you can create the roles and responsibilities also. So you are in a way telling your processor, sub-processor, or the gentleman who is working, the third party who is working on your personal data collected on your behalf, the exact data management lifecycle for the data. The document as to how the data would be managed and clarify the roles and responsibilities between controller and processor. That's the most important role of a DPA, and legal regulators say that these are the important things that you should do. So then because these are important things to be done, then you should get these into picture immediately. Absence of a DPA or a data processing agreement can enforce fines and actions. Now let's look at some of the regulators. GDPR, the European ones. Their Article 28 requires a written contract between the controller and the processor, right? They want that the controller and processor should sign a document that must include nature and purpose of processing, duration and type of data involved, and rights and obligations of the controller, right? Nature and purpose of processing, duration and type of data involved, and rights and obligations of the controller and also of the processor. Non-compliance fines in GDPR can go up to 2% of the global turnover of the organization. So it's very important that they have a DPA there, right? Other regulations may or may not use the word DPA, but the Indian DPDP Act says you should do lawful processing, which is fine, and there has to be a contractual clarity between the fiduciary and the processor. How do you have that? Sign a DPA. Right? Sign a DPA. Californian government says there has to be an agreement to include usage limits and consumer rights in the document. So the third party in California has to agree, and both of you need to mention what would be the usage limit of the personal data and how would you ensure that the consumer rights are taken care of. What about Brazil? Brazil wants you that you define the shared responsibility between the controller and the processor, or between the fiduciary and the processor, right? Again, DPA does the same. So whether you are calling it a DPA or not, you are following DPA, right? Overall commonality, everyone wants a clear role and responsibility between the relationship of a controller and a processor, of a fiduciary and a processor and a sub-processor, as the case may be, in writing with commitments signed between the two parties. Therefore, we are looking for signing a DPA. That's very, very simple. Key takeaways. DPAs are not optional. They are critical documents. They are required whenever you are getting processing done by third parties. They help you ensure compliance. They help you ensure transparency. They help you ensure accountability. DPAs apply to cloud service providers, CSPs, payroll processors, CRM application vendors, and business analytics application vendors. So these kind of outsourced applications or processes should have a DPA backing them up. Missing or weak DPA is a very serious compliance liability. Please don't take such a risk if there are privacy regulations applicable in your country. DPAs reflect your commitment as a fiduciary or a controller to safe third party processing, ensuring your principals and subjects that even if the processing is done by a third party, their personal data is in safe hands. So that's about the legal mandates with respect to DPAs. I hope you like the content of the video. Please press the bell and the like icon. Subscribe to my YouTube channel and share your feedback in the comment section. Thank you.